That's it. I may be permitted to mention one matter pertaining to family pension. That's it. To come up on Monday. That's it.
Monday not possible.
That's
You can take 27th, Monday 27th.
That's it.
Yes.
My lord, I'm saying for listening this petition, my lord. My lord, identical matter is coming tomorrow, my lord. Should we take up this matter, my lord, tomorrow? For
Motion.
motion.
Yes.
Wait, please, your lordship. My lord, I filed this writ petition yesterday, my lord. A transfer order was issued on last Friday, 10th, and I'm sought to be relieved on Saturday, my lord, 15th, day after tomorrow. So I pray that.
What is wrong with the transfer?
Well, it's grossly in violation with the transfer policy, my lord. There are several counts on which I have challenged.
I pray for listing of two repetition lordship. One is transfer petition and another is regarding cancellation of appointment of Anganwadi helper.
Transfer petition.
Lordship, they are availing the stay order for last 2 years, lordship.
Transfer petition is not this.
Not transfer petition, lordship, transfer matter. Sorry, lordship.
Choose a date next week. Friday not possible.
Lordship.
Next week, Wednesday or any other day after that. Yes.
And item number 10, my lord. Item number 10 has been tagged with item number 9. 10, my lord, I'm not pressing, my lord. Because, my lord, my cause of action, my lord, and my lord is no more there. I have challenged the appointment of the petition.
Of this code, this bench. Item 10, you are not pressing.
Not pressing, it's been tagged with 9, my lord. And my lord, so far, item number 19 is concerned, my lord.
1 minute. Item 10, Mr. M. Dr. Counsel for the petitioner submits that he has he has instructions not to press this rate petition. First of Mr. D.R. Gogoi, learned counsel for the respondent number 5, and the learned government advocate Assam are present and do not have any objection if the prayer is allowed. In view of the above, this rate petition stands disposed of as not pressed. Yes.
So for the item number 19 is concerned, my lord. Yesterday, my lord, afternoon, we were served with an affidavit, my lord, opposition, my lord. Additional affidavit, my lord. But that is not also on record. And I would like to find a reply, my lord, before 4 weeks' time, my lord.
Mr. M. Dr. Learned counsel for the petitioner submits that a copy of the counter affidavit filed by the respondents has been served upon him only yesterday, and therefore he will be granted 2 weeks' time to obtain instruction. 4 weeks' time to obtain instruction and file rejoinder. First, prayer allowed. Register to list this case again after 4 weeks by tagging the counter affidavit with the record of the case.
Diploma.
May I please your lordship? May I please your lordship?
Yes.
Lordship, item number 33 of the supplementary list, lordship. I have some personal difficulties today because this matter has been listed, lordship. Yesterday it was listed, but due to overlook, lordship, I could not appear, lordship. Okay. After 23rd, lordship.
Item 33.
Yes, your lordship.
As prayed for by learned counsel for the petitioner, this matter stands adjourned and shall now be listed again on 25th of March 2023.
Highly obliged, lordship.
No, 25th, 24th of.
I have responded number 2 for in this case. Respondent number 2, I will pay.
Mr. T.C. Chutia, an additional senior government advocate, Assam, is present on behalf of the respondent number 2. Yes.
My lord, I beg to mention for listing of the pending matters, my lord, in admission column.
Any day after Bihu,
My lord, before,
what is the urgency?
my lord, regarding promotional matter, my lord, from great.
After next Bihu, not Bihu, promotional matter, what is the urgency? You have it after Bihu, yes.
May I please, your lord. No, item number 35, my lord, it has been wrongly listed, my lord, today. Except bench 4 matter, my lord.
Mr. M.K. Das, counsel for the petitioner submits that item number 35, that this matter has been wrongly listed before this court today. According to the learned counsel, this is a bench 4 matter. Registered to verify in this case, civil bench 4 matter. Registered to verify in this case accordingly.
Interim, my lord, there is an interim, my lord.
Interim order passed earlier to continue.
Deeply obliged.
Supplementary list for motion item 34.
My lord, before my learned friend places the instruction, if a lordship would kindly have the rule once, my lord.
Give the rules. Get the copy of the judgment by High Court single bench I had given yesterday. Give us back the judgment copy. Which
Look.
took this. Yes,
My lord will kindly come to rule 11, my lord.
which rules you are referring to?
11 and 12
No, no,
of the
Assam-
1964 rules, my lord, Assam Services Discipline and Appeal Rules.
she has given me the entire mountain. Let me find out the ashwagandha from here. Which page is the rules?
If the lordship holding this book, my lord.
This one.
If the lordship will kindly come to the index, there it is indicated.
Page 426.
Lordship got it?
Yes, 426.
Yes.
Right.
Please come to rule 11. Where the services of a government servant are lent to central government, any state government or local or to local or other authority, the borrowing authority shall have the power of appointing authority for the purpose of placing him under suspension and of the disciplinary authority for the purpose of taking a disciplinary proceeding against him. Provided that the borrowing authority shall forthwith inform the authority which lent his services of the circumstances leading to the order of his suspension or the commencement of the disciplinary proceeding as the case may be. Well, I'm pausing here for a moment, my lord. We are dealing with a situation where an officer is lent to another department. Now, when he is in borrowing department, my lord, essentially the sub-rule 1 visualizes a situation while the officer is on deputation, he commits some misconduct. Here, in this case, of course, it pertains to a misconduct which is anterior in point of time. I'll come to that later. Now, it says that it is the borrowing authority who is the authority to, my lord, suspend him or to take the decision regarding holding of disciplinary proceeding. However, my lord, a statement will be drawn up and it will be sent to the lending department. Now, please come to the proviso. Provided that the borrowing authority shall forthwith inform, not 2, sub-rule 2. After, my lord, informing the lending authority. In the light of the findings in the disciplinary proceedings taken against the government servant, if the disciplinary authority is of the opinion that any penalties specified in clauses 1 to 3 of Rule 7 should be imposed on him, it may, subject to provisions of Rule 9 and in consultation with the lending authority, pass such order on the basis as it deems fit. However, rule, envisages a situation, even if the borrowing authority is empowered to suspend or initiate disciplinary proceeding, but when it comes to, my lord, imposing punishment, then, my lord, it will be done in consultation with the lending authority. Then, my lord, the second proviso. Provided that in the event of a differences of opinion between the borrowing authority and the lending authority, the services of the government shall be replaced at the disposal of the lending authority. Now, this is the catch. Now, supposing, my lord, as to what punishment is to be imposed, both departments cannot, the borrowing and the lending authority cannot concur. In such a situation, my lord, the lending authority has the option of bringing him back and take whatever necessary. Now, my lord, we are confronted with a situation where alleged misconduct is not, committed when he is in deputation. In fact, it was in deputation, but with another organization. Now, in such a situation, what will happen? The rule appears to be silent. Now, my lord, will it not be, prudent or rather rational to think that the proviso, as in, my lord, sub-rule 2, that will apply? But in any case, my lord, in view of the express provision in the rules, we cannot recognize any power of the lending authority, either to place him under suspension or to initiate disciplinary proceedings. It lies with the borrowing authority. Rule 12 also similar, my lord. Rule 12 speaks of the power of the borrowing authority. So therefore, my humble submission is, my lord, the rule does not envisage or recognize a power of the lending authority to either suspend a government servant or to initiate disciplinary proceeding. And to the same effect is the judgment of our High Court, my lord, interpreting the rule. But my lord, we can, my lord, of course, my lord, every rule must have some exception. If there has to be some, scope for reconciliation. So my lord, the scope of reconciliation is if this, because it is the cadre controlling authority is the personnel department. If the personnel department feels that the case is of such a nature that it calls for disciplinary proceeding, then necessarily, my lord, they are not helpless. They can always write to the borrowing authority, send him back. So, my lord, but we can't recognize a power at the hands of the lending authority once an officer is on deputation.
Mr. Chaudhary, what you are contending appears to be the purport of the rules.
Yes.
But I'm finding it very difficult to accept the logic behind these rules.
No, my lord. At times, lordship will have to accept the interpretation, my lord.
No,
My
that's
lord,
right.
at times that personal thing will not come here because the lordship
No,
is
it's not
interpreting a rule.
personal. It's not personal. As a
What I
judge,
mean is the view of the court.
as a judge, you see, you look at it dispassionately. Don't forget for a moment the brief you're holding.
When maybe the expression personal was not appropriate, my lord. What I feel is the view of the court also has to tell you it was the literal interpretation of the rule.
But that's right. We'll come to that a little later. Let us see what he has to
Yes.
say. But on
Yes,
a
yes.
slightly larger platform,
Yes.
you see what is being proposed
My
by
lord,
this.
that's why I said it is not my argument that the appointing authority is divested of the power to either place him under suspension or to initiate disciplinary proceeding under all situations. No. There are situations where they can resort to. I think that we have to call out from that proviso to the sub rule 11(2), where it says, provided in the event of difference of opinion between borrowing authority and lending authority, the services of the government shall be replaced at the disposal of the lending authority.
No, Mr. Chaudhary, I'm on a slightly different point. Let us look at this case. He is a member of the Assam Civil Service.
Yes.
He is appointing controlling authority is the personnel department Assam.
Yes, yes.
He alleged misconduct happened when he was a part of the corporation, which is a Assam government corporation.
Yes. But that again was in foreign service.
That's right. That's right. In a way, maybe you can say that. Now he's
No, even now he does not cease to be a my lord's Assam Civil Service officer.
right.
Even now he is. Only
So,
thing is,
this expression borrowing and lending, as long as an officer remains within the control of the cadre controlling authority. Supposing today, if he was in deputation to central government, then would the matter be same as if he is in deputation with the BTC?
Yes, because the rule does not make any distinction between central government, state government, or other local authority. Same situation. Even CCA rule also same provision. Central Civil Service classification, control, and appeal rules, same provision.
Let us see what
Yes.
he has to say.
But firstly, the decision relied by the petitioner. In that case, the situation was when the person was within the administrative control of the Karbi Anglong Autonomous Authority, and in that case, in the Reboti Mohan Hazarika case, the decision was that although the word deputation was not in the order of the government, the honorable court said that it is a deemed deputation. So he was under the administrative control of the Karbi Anglong Authority, and the Karbi Anglong Authority is the who can suspend and take disciplinary action against him. But here the facts are different. But under Rule 6(1), the appointing authority.
The question is not of facts. Question is of purport of the rule.
True.
Whatever be the facts, the
True.
rules won't change. Interpretation of the rules can't change.
True. The 6(1) of the rules, the disciplinary and service rules, 1964.
Yes.
It relates to suspension. It provides that the appointing authority or the authority which
Yes.
the appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place the government servant under suspension, where a disciplinary proceeding against him is contemplated or is pending. Well, the personnel department under as per Rule 6(1) of the discipline and appeal rules is the appointing authority for the petitioner, and being a SES officer, they are the cadre controlling authority, and his action when he was not under the BTC is in question. Lordship, the office memorandum is also there, my lord. I have given a copy, my lord.
Hmm.
The WPT and DC department has issued an office memorandum on 16th of October 2004. Kindly come to J, my lord. Serial number J.
Yes.
It starts like the first para that whereas in pursuance to the memorandum of settlement reached between the government of Assam, government of India, the Bodo Liberation Tigers on the 10th of February 2003 in Delhi, in presence of the Deputy Prime Minister of India, it has been agreed to
You
create.
are referring to J,
I'm referring to J, Lordship.
JK, J.
Yes,
Therefore, Jaipur.
J, J.
Jaipur starts with the state government shall consult the
Yes,
council.
yes.
Ah.
Yes. But I'm referring to the second sentence. It starts with I'll read the whole. The state
Mr.
government.
Nath, why don't you first come to the rules? The rules and office memorandum are two different things.
Lordship.
The 1964 rules are statutory rules, correct?
True.
So if the rule says that the borrowing authorities will have to place in suspension, the borrowing authority will have to place in suspension. That these set of rules have been interpreted by a coordinate bench, wherein it has been held that the petitioner whose services were under at the disposal of the autonomous council, they could only have suspended him and not he was also an officer of the Assam cadre. So if that interpretation is taken and the rules prima facie say so, you have to first address the court on the rules.
But since Lordship has seen the rule 11, Lordship has my learned senior counsel has already
Yes.
submitted the rules.
Yeah.
But rule 11 doesn't contemplate this particular situation where we stand today in this particular
But
case.
why do you say so? These are matters of intricate hearing. Contemplation means that means you are saying this judgment is not.
No, but rule 6(1), I have pointed out the appointing authority is the authority who can suspend a person.
That is correct, but has the state preferred any appeal against this judgment?
No, because in that case, the issue was whether he was under deputation under the Karbi Anglong authority or not. Kindly see paragraph 1 is the facts noted, and
Mr. Nath, looks difficult. I may be open to persuasion, but then unless the judgment is found to be a matter of reconsideration and referred to another bench, it will be difficult. This is what your rules say, and this is what the learned senior judge has interpreted. You have not preferred any appeal.
In fact,
How can, while issuing an interim order, I take a view which is contrary to the ratio of the judgment?
In fact, this decision was Lordship, the particular provisions of the office memorandum, paragraph 7, kindly see, particular provisions of the office memorandum which was signed between the Karbi Anglong authority and the state, that has been noted. E, F, G, H, those are considered, and particularly considering paragraph H of that office memorandum, that was considered by the honorable court. Here, I am referring to this office memorandum, the clause J.
The only answer is the disorder has to be.
Mr. Nath, difficult because in this case also he was working as joint director of sericulture. Then he was sent on deputation to the Karbi Anglong Autonomous Council. During his continuance there, a show cause notice was issued to him alleging misconduct during his tenure as the joint director of sericulture. Then he came to the court.
Under the authority of the Karbi Anglong. She was under the authority of the Karbi Anglong. And at the instruction of the Karbi Anglong, he did taken some action. Can you for a moment kindly see J, the clause J, which I'd like to refer. Can you see the second sentence? The state government shall take necessary action under the relevant rules and procedure against the officers and staff found involved in any prima facie case of misconduct, dereliction of duty, etc., during the period of deputation to the council and even after they are repatriated to the state government, in case of any difference of opinion between the state government and the BTC on such matters, a reference will be made to the WBT and BC department for final decision.
All right, now the next question is, what purpose will be served by putting him under suspension? You can't even initiate a disciplinary proceeding against him unless he is repatriated to his parent department.
Well, disciplinary proceeding is already it is initiated, it is started. And kindly see the magnitude of the irregularities. It is
At the moment, he is not under your administrative control. How can you proceed against him? Was it not proper for the government to repatriate him and then proceed against him? Why this easy recourse has not been taken and rather unnecessary complicated questions of law arguing against the decided cases?
It requires, of course, it requires some consideration.
Easy way out would have been what Mr. Chaudhary had also suggested yesterday. You could have easily repatriated him.
Yes, that is the only answer.
Well, state can't help it. Mister. We'll have to examine the matter.
And Malad may kindly out give us the liberty if they want to in the meantime.
That liberty is not required. They're always.
That observation will make Mr. Chaudhary. This order will not come in the way if they want to repatriate him. And
No, they can take to any legal recourse available to them. Lordship will not advise the government of
no,
Assam.
will not advise.
They have got law officers.
Mr. Chaudhary will not advise, but that liberty has to be given. Otherwise, the government will feel that the court has restrained them from it.
Lordship may clarify that.
Your Honor, see, this
Of
is
course,
just
I
a
follow.
technical.
I would like to give one small piece of suggestion to my learned friend, which I did as a law officer of the state. Every case is not meant to be defended when it is undefended. My lord, here is a case my learned friend should have said, all right, we are withdrawing this order, give us liberty. That should have been the approach.
No,
I
I
don't know
feel
why
I
they are
am
not doing
surprised.
that.
That
Why
is
they are
why.
defending an indefensible
That is
case?
why the time was given yesterday. But you
If
did
I
not
am
do
the
it.
in my learned friend,
No.
I would have done that.
Why this obstinacy? I don't
I do
understand.
not know, my lord. As if, my lord, an order passed by the government, at any cost, it has to be defended.
First of
It's
all,
a new
it's-
culture which is growing, my lord.
It's surprising that what is the logic behind having a rule like this? If you could have added that provided the alleged misconduct pertains to his tenure in the borrowing department, then we can understand. But you have not put that rider.
No, that is not.
So now he has done something somewhere, he sent somewhere else, and the government here is the cadre controlling authority, but cannot do anything. You are responsible for putting you into this situation. Why have you tied your hands like this?
That's true.
You have tied your hands.
I can't.
You have tied your hands, and if the rules had left some scope, it has been completely sealed by the judgment of the learned single judge, which you have accepted. Now you are arguing this and that. How can the court do it?
The
After all,
situations-
court proceedings have to follow some discipline.
Look, Lordship, I'm making my submission that the situations are different. That particular situation in the present case is not contemplated, and it was also not the case.
No, but how are you distinguishing the judgment? If you're distinguishing it, then do it. Situation, no, facts. Judgments are not passed on situation, are passed on facts. If you want to say that it is distinguishable in fact, I'm willing to hear you. Show it, project it. How is it distinguishable?
At this stage, Lordship has already proposed to pass the order. Lordship may pass the order, giving us liberty. We'll examine.
No, but I'm open to persuasion.
Lordship.
If you don't want to pursue, then what can I do? Yes, heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. Yedas, Learned Counsel appearing for the writ petitioner. The petitioner hearing is a member of the Assam Civil Service Cadre. Presently, his services are placed on deputation under the BTC authorities. Assailing the order dated 9/2/2023, by means of which the petitioner was placed under 9/2/2023 issued by the Secretary to the Government of Assam, Personnel capital A Department, by means of which the petitioner was placed under suspension by invoking powers under Rule 6, bracket numerical 1, bracket close, bracket small a, bracket close, of the Assam Services, bracket discipline and appeal, bracket close, rules 1964. The instant writ petition has been filed. Full stop. It appears that based on the enquiry report submitted by a high-powered committee alleging irregularities in the recruitment process initiated under the supervision of the petitioner while he was serving as the managing director. Well, he was the managing director, is it, of the Assam Fisheries Development Corporation Limited, bracket AFDCL, bracket close, a corporation of the state government of Assam, comma. The authorities are proposing to initiate disciplinary proceeding against him and hence the order of suspension. Full stop. By placing reliance on the provisions of Rule 11 of the rules of 1964, Mr. Chaudhary, senior counsel for the petitioner, has argued that as long as the petitioner is on deputation under the BTC authorities, it is only the borrowing department which can issue the order of suspension and not the lending department. Full stop. To drive home the aforesaid point, Mr. Chaudhary has also placed reliance on a decision of this court rendered in the case of Rebati Mohan Hazarika versus State of Assam and others, reported in 2013, bracket 5, bracket close, GLT 708, to contend that the aforesaid issue has been settled by the aforesaid judgment, wherein it has been categorically held on interpretation of Rule 11 that it is only the borrowing department which would have the authority to place the civil servant under suspension. Full stop. Mr. D. Nath, learned senior government advocate, Assam, on the other hand, submits that although he is not disputing that the petitioner is presently on deputation and his services have been placed under the BTC authorities, yet, according to Mr. Nath, the personnel department of the government of Assam, being the cadre controlling authority of the petitioner, cannot be divested of its power to place the petitioner under suspension. Full stop. According to Mr. Nath, there is no scope for issuing an interim order in this case as prayed for. Full stop. I have considered the submissions made by learned counsel for both the sides and have carefully gone through the provisions of the rule. Full stop. A bare reading of Rule 11 of the rules of 1964, it can be disposed of actually if you agree. Rule 11 of the rules of 1964 clearly projects that the power to place a government servant lent to the central government, state government, or to local or other authority would lie with the borrowing authority. Full stop. The provisions of Rule 11, no, you're right. Rule 11 has been interpreted by the learned single judge in the case of Rebati Mohan Hazarika, bracket Supra. Full stop. That was also a case where the delinquent whose services were placed under the disposal of the Karbi Anglong Autonomous Council, bracket KAC, was placed under suspension due to alleged misconduct on his part carried out while he was serving as the additional director in the sericultural department under the control of the lending authority. Full stop. Right? The learned single judge had made the following observations in paragraph 11, which is reproduced here in below. Full stop. Mr. Nath has fairly submitted that the state has not preferred any appeal against the judgment rendered in the case of Rebati Mohan Chaudhary Supra. If that be so, there can be no doubt about the fact that the decision, the ratio of a decision rendered by a coordinate bench would have a binding effect on this court, full stop. Situated thus, I am of the view that the matter would call for further examination, full stop. Issue notice of motion returnable in 4 months. Since Mr. You are appearing for?
1, 2, and 6. Right?
Since Mr. D. Nath has appeared and accepted notice on behalf of respondent numbers 1, 2, and
6.
6, Mr. R. Dhar, Learned Standing Council, WPT and BC, for respondent number 3, and Mr. S. Rabha, Learned SC, BTC, for respondent number 5. Service of, you are for? Mr. P. Sharma for respondent number 4. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Learned Departmental Council, requisite in numbers, so as to enable them to obtain instruction in the matter. Full stop. Heard in the prayer of interim relief, having regard to the facts and circumstances of the case and the decision rendered in the case of Rebati Mahan Chaudhary Supra. This court is of the opinion that the petitioner has succeeded in making out a strong prima facie case. As such, as an interim measure, it is hereby provided that operation of the impugn order dated so and so shall remain suspended until further orders. Full stop. However, as a matter of clarification, it is provided that this order would not come in the way of the cadre controlling authority of the petitioner to issue a fresh order of suspension subsequent to his repatriation in the parent department, if so deemed, if so felt necessary.
Well, possible stay page 38, so called also same position, madam. The suspension is page 36 and 38 is the so called. That we have challenged both, madam.
36, 37, duita, show cause
36
notice,
and 38.
36 and 38. Show cause notice dated so and so and suspension order.
One.
Report or a duita divorce suspension order. All right, yes.
Go. If you like.
Lordship, before he submits, Lordship, there is a stay vacating petition. We'd like to file our objection, Lordship.
Which order you want to vacate it?
My lord, page number 19
Page number 19.
starts from page number 20. The relevant part is at page 21. The final seniority list dated 13/9/2022 has been directed not to be.
Learned judge is available. Let it go before the appropriate bench.
My lord, it is not a review application otherwise. I'm leaving it up to your lordship, but it's not a review.
Nowadays, stay vacating doesn't go to the same judge.
I don't.
Huh? Why? It should go to the same judge.
Otherwise, my lord, so far my understanding goes, since it's not a review application, it can be subject to what your lordship, my lord, says.
Final seniority list of senior assistants in Silchar.
Well, in a concise manner, if I may just be allowed to place the facts, man. The applicant was appointed as LDA in the year 1993. His service in the post of LDA was regularized in the year 2001. His services in the post of UDA was given in the year 2008. Thereafter came an opportunity of being promoted to a post called Divisional Head Assistant under Water Resource Department. Now, to that effect, my lord, applications were invited, and applications were invited within the department. The employees serving within the department were given to apply. There was a selection committee that was.
So why do you want the order to be
My
vacated?
lord, here what has happened. First of all, they approached this honorable. He approached this.
Why do you want the order to be vacated?
My lord, because the writ petition that has been filed is in itself not maintainable. There have been two other litigations, one finished, one is pending. In that writ petition, he did not get the.
That is the ground, there is no urgency.
But urgency is because of the fact that at the fag end of the applicant's service career, he is anticipating a promotion. He is.
You should have said that as the reason. You are
But
saying
that
this,
is
that, all kinds of
categorically
things.
pleaded.
Huh?
That is pleaded also, my lord.
that is pleaded also. I have
But
taken that.
that is your only ground of
My
urgent.
lord. Now, my lord, they came before this honorable court in writ petition 3727 of 2022.
Hmm.
Asked
So
for
when is
stay-
his career ending?
My lord, his career, he is now 56.
6 years left, lordship, 6 years left,
Super
6 years.
2 weeks time to file objection.
Lordship,
Then we'll take
file.
up. the
My lord,
matter.
226,
Yes.
3, my lord.
Yes,
application.
yes.
Well.
Heard Mr. D. Chakravarti and counsel for the applicant. This IA has been filed with a prayer to vacate modify alter the order dated 21/9/2022 passed by this court in WPC number 6236 of 2022. Mr.
And Bormon lordship.
N. Borman, learned counsel for the writ petitioner stroke OP, prays for 2 weeks time to file objection. Mr. R. M. Das, learned SC Water Resources Department is also present on behalf of the.
I have a small
official
prayer, lordship.
respondent.
Lordship, here we have challenged the initial appointment of the applicant.
Hmm.
So lordship, records are necessary. If your lordship,
Nothing doing. We'll just consider his application. If we feel it is to be vacated, we'll vacate it.
Lordship.
Otherwise, we'll dismiss it.
lordship,
Don't expand things unnecessarily.
lordship.
On the
that will be
request of
necessary
Mr.
for-
Borman, learned counsel for the OP number 1 writ petitioner, this matter is directed to be posted again on 29th of March 2023 as a fixed item. The OP may file objection, if any, in the meantime. This IA will be taken up for disposal on the next day.
I'm deeply obliged,
Interim order passed earlier to continue till then.
lordship, obliged.
For admission, I can given 3.
Madam, this related to directed against the order of punishment passed by the member NHP, member NHP Dhuri against the petitioner who is the chairman in his establishment. And in another WPC 6429, Conjuma Begum is the wife of the petitioner in the petitioner Ananda Prasad, my lord. Both of them were serving in the same establishment, my lord. What happened, my lord, on? That is, your lordship, kind of see the page, para 9, my lord. Para 9, lord. Page 7, my lord, page 11, para 7. That the petitioner back to Swami that as the case, he was availing casually from 26/2017 with a punishment to leave the headquarters. And also on 27/6/2016, and hence the petitioner sent an applications for the unnamed, my lord, because he was going to treatment in the Bombay, my lord. So he has filed an application on 22 by email. That application is, my lord, is page 24, leave application. Where is the order of penalty? Which page? Penalty is, my lord, actually last para. Not for a page, my lord, 98, and extra 21. Actually, he was registered as suspension order withdrawn. There is a penalty of withholding of 2 increments, correct? 2 increments, my lord. You want that to go? Yes, my lord. Where is that order? My lord? Where is that order? Page 98, my lord. Last page up, the penalty. The last page up, my lord, penalty, the relevant, he has filed second so-called notice. It is stated that I am constant to accept the so-called notice, reply of the delinquent staff, and the same is rejected in view of the finding in the inquiry report. Inquiry report is 11 is page 70, my lord. So the Ananda Prasad, Chairman of the Office of the Members MSCT is hereby reinstated to his service according to deciding withheld to increment to come into effect from the date of this order. This suspension period shall be treated as a duty, and allowance of the suspension period shall be regulated under Rule 54B. The period of unauthorized leave from 27/6/2016 to 28 is also adjusted to the pair of the unleave made by him. He has earlier applied for the unleave, my lord. It was not granted, petitioner rejected, but subsequently same was granted, my lord. Reinstating him and the withdrawing suspension order and they giving all the benefit, the thing is to be serviced in the during the suspension period, my lord. So when the all has been regularized. Where is the order granting leave? Leave was not granted. Page, your lordship kindly see the page 24, the leave application. Leave was granted or not granted? Leave was earlier not granted, and subsequently it was granted. This order I am reading. Where is that order? Which page? Page 98 page. Last paragraph. 98 last paragraph. Ananda Prasad Shiosaka of the office of the members of the MSCP is hereby reinstated to his service, deciding to withhold to increment to come into effect from the date of the order. His suspension period shall be treated as on duty, and allowances of the suspension period to be regulated under Fundamental 54. The period of the unauthorized leave from 27/6/2060 to 28/6/2000 is to be adjusted from the care of the unleave. Yes, what is wrong with this? My lord? What is wrong with this order? No, because he was not unauthorized action. He has given the unleave application. It is in the my lord page 24. Unleave application was given, but that unleave was rejected only grounded it was not supported by the medical certificate. But he has gone for treatment. When he was going to treatment, he sent the application of how he will admit the certificate without taking the treatment, my lord. So he was immediately next day, it was rejected on the ground that it was not supported by the medical evidence. You have to come and join immediately. But I was on treatment. Next, I have again. Where is the document to show your treatment? My lord. During that period, where is the medical document? The annexure 1, my lord. Annexure 1, page 23. Page 23, annexure 1, my lord. That is subsequently I have submitted. So he went to Bombay to get a treatment in a Mohalla clinic. Your client went to Bombay, Andheri West, for getting a specialized treatment in a Mohalla clinic run by a MBBS doctor. By leaving aside so much of medical facility in Assam. That I don't know what treatment he has taken there, but my point is that his absence is not unauthorized. Or more than he has gone, he has sent medical certificate, leave application. It is in page 24, my lord. And after end of this period, he has again sent an extension. That is in page 43, my lord. And thereafter he has sent another application for granting leave, my lord. But he has a leave in his credit, my lord, page 71, my lord. According to the letter, No, Mr. Sharma, listen, the point is slightly different. When he went, at that time, it was not authorized. No. Only that he was 2 days scheduled leave first. And next 2 days was notified holidays, 25 and 26. On 27, he has gone. On the same day, he has sent for email this leave application, my lord. And authority has received it on the same day. But after 2 days, it was rejected on the ground that it was not supported by medical certificate. But he has gone for treatment. How he will enact a medical certificate, my lord? Actually, there is a complaint against your client who is an accused in a police case for Abducting,
Police case
kidnapping
different.
a
Police
lady.
case, his brother, the Unduma Begum, the copies, he has love affairs with his minor. Both of them have gone. Therefore, his brother has filed in the FIR against his minor. That's why they had married there, and that was crossed by the High Court, my lord. This FIR was crossed, my lord. That is, it is my lord, page 26.
Page 26.
Six.
Where is the order of the High Court?
Or yes, I'm pointing out it, my lord. Medical certificate, final order.
Yes. Yes, Mr. Das, you are appearing?
Yes, madam.
Yes. What do you have to say?
Lord, we have filed the affidavit. The Lordship will kindly take the affidavit in opposition, page 2, para 5.
Hmm. Yes.
That with regard to the statements made in para 5 and 6 of the petition under reply, your deponent begs to state that Srimati so-and-so was suffering from some medical issues relating to her skin, and there was no reason behind Srimati so-and-so receiving treatment from a doctor who is specialized in respiratory problems. It is pertinent to mention that the medical certificate issued by Sri so-and-so is dated 23/5/2016 and not 23/7/2016. In the certificate dated so-and-so, the petitioner was required to follow up after 15 days for further treatment. The petitioner must have annexed all the certificate issued by Dr. So-and-so, including the medical prescriptions disclosing the details of treatment received by him in between so-and-so to so-and-so. But instead, a medical certificate came to be annexed, which was issued prior to the treatment received by the petitioner. These are all afterthoughts, my lord. He remained,
What is the period for which he sought leave?
sorry, my lord.
He has applied for leave for which period?
He initially applied for leave for 4 days. If I'm just giving the date, my lord.
That is, my lord, he applied from 27/6/2016 to 28/2016. First leave application. And secondly, another was sent. It was in page
No, no, no.
23, taking extension and application. And the other,
CL from 23/6/2016 to 24/6/2016. And he remained absent from duty from 26/7/2016 to 26/8/2016.
26 is the government notified holidays.
And Lordship will find his date from page 89.
26/7/2016 to 26/8/2016.
He remained absent, unauthorized.
But
and
according to him, he had submitted a leave application,
Yeah.
earned leave application.
initially from 23/6/2016 to 24/6/2016, he was on CL. Thereafter, he remained
23 to
absent.
24 means 2 days.
Yes. Lordship will find page 89, that is the inquiry officer's report.
2 days he was on CL.
CL. Thereafter, he remained absent. my lord.
All right, and he says 25 was a holiday.
Yes.
So according to him, he had to go to Bombay for medical treatment. And while returning, after return, he submitted an earned leave application, which has also been granted subsequently.
Yes.
Right. So if the leave has been granted, then where is the unauthorized absence? That is his question.
That is my point. my lord.
You say that you have remained unauthorizedly absent for this place to this place, but I am regularizing it by granting you leave. Are these two not mutually contradictory?
Lordship, yes. We'll just go through the order, page 21, my lord.
Hmm. Page 21 is the affidavit.
No, my lord, of the writ petition.
All right.
Page 21 of the writ.
Yeah, both.
Following the inquiry report is, sorry, my lord, I'm extremely sorry, annexure 21, my lord, page 97. What was the order passed, my lord?
Okay. Yes, yes. Please read, please read.
It's following the inquiry report is second show cause notice was issued to the delinquent staff Sri so and so with regard to proposal to withhold 2 increments after his unauthorized leave from his duty, as well as headquarters had been established. The show cause reply has been received from the delinquent staff challenging the inquiry report, holding same being not tenable in law. The inquiry report has been prepared after due compliance of the rules in Assam Service Disciplinary Appeal Rules 1964, as well as Article.
All right, this part is done. So inquiry was held.
Yes.
All right.
Then, my lord, in the inquiry held, so and so staff has been found unauthorized absent from his duty, headquarters following working days. The unauthorized absence from duty as well as headquarters.
So which is the period during which he was unauthorizedly absent? Today, what is the situation?
From 27/6/2016 to 26/8/2016.
But for that period, he is on earned leave now.
No, the lordship, that was, lordship will kindly see the last portion. Sri so and so reinstate in service, deciding to withhold 2 increments to come into effect from the date of the order. With his suspension period shall be treated on duty and allowances of suspension period to be regularized under so and so. The period of unauthorized leave from so and so is to be adjusted to the prayer for earned leave made earlier.
Correct. So he made a prayer for earned leave, which has been granted.
What is his prayer? Lordship will kindly see. Prayer in the writ petition, my lord.
Don't get into hyper-technical, please, Mr.
No,
Gar.
I'm not going into hyper-technical. He is challenging this withholding of 2 increments. This penalty he is challenging.
Mr. Das, you have understood, either you have understood and you are on some pretension, but giving you the benefit of doubt, I'm putting the point once again, then I'll close the matter.
Lordship.
The question is, he went on leave without the leave being granted. That is acceptable.
Yes.
But the charge against him is he was unauthorizedly absent. And the period is 26/7/2016 to 26/8/2016.
Yes, my lord.
Right?
Yes.
But the fact of the matter is that he had submitted an application for granting him earned leave. That was submitted after he had returned back. Correct? That application has been allowed.
Lordship.
So therefore, where is the question of unauthorized absence? That's all I'm asking you.
Unauthorized absence remains. The disciplinary authority, I'm just explaining, my lord. He was,
If the charge was that he proceeded without applying for leave, and that is not permissible under the law, then it is another thing. But his absence from duty has been authorized now.
Lordship will kindly read the charge then again.
Where is
Lordship
it?
will kindly read the charge.
Where is it? page number?
I'm just taking it. 61, sorry. Page 60. 51. It starts. That you being so-and-so officer of MSCT so-and-so were found unauthorizedly absent in your duty as well as from headquarters from so-and-so till your date of suspension on so-and-so, even though you received the order notice dated so-and-so, rejecting your prayer for earned leave. For the aforesaid act omission conduct, you are charged with negligence of duty, dereliction of duty, and breach of discipline in your office work and duty, which amounts to misconduct. Now, your lordship will kindly come to the statement of imputation, page 62. Whereas,
So his application for leave was rejected.
yes, and
Where
it
is
was
the order of
rejected,
rejection?
thereafter proceeding was initiated.
Where is the order of rejection?
I'll just take it. Your lordship will find page 55.
It's a Das, you have to hurry up a little more.
My lord, I'm extremely sorry. Some, my lord, Aji, today what happened, I missed my file, my lord. Mr. Nair was appearing. I'm just doing, lordship will kindly accommodate me. I'm taking the B file and I'm just trying to.
Then we'll have it on Tuesday. You come prepared. Tuesday. All right, I had Mr. K. Sharma.
I beg
counsel
apologies.
appearing for the petitioner, also had Mr. H. Kedar. Learners, counsel appearing for the respondent numbers.
Respondent number, my lord. High Court. 2 and 3, my lord.
2 and 3 and 6, a little accommodation. With the leave of this court to address his arguments in reply on 21st of March 2023. In view of the above, this matter be posted again on 21st March 2023 as a fixed part matter. Yes, please come prepared. Huh? Yes, Mr. Gurwal, Government Advocate Assam is present on behalf of the official respondents.
My apologies.
But you come prepared.
Yes, my lord.
Can't take so much time.
No, I'll satisfy, my lord. I'll satisfy your lord.
I want to know what is the law. Show me a decision.
Yes, my lord. I'll come. In fact, I have prepared those things.
Leave statement is also there, furnished to us by the 218 days leave in schedule.
I'll satisfy.
Yes, next one.
May please, Your Lordship. Your Lordship, in this matter, the petitioner is claiming regulation of service in the ONGC, Your Lordship. Respondent number 2 filed, respondent number 2, an industrial dispute was raised by respondent number 2 and another organization, Your Lordship. And an award was passed whereby it was directed that all these employees should be regularized from service. Thereafter, they approached the honorable, this honorable court. 2 awards came together and a writ petition was, 2 writ petition was filed. That writ petition was dismissed against the ONGC, Your Lordship. Against that, the ONGC preferred a writ appeal before this honorable court. And then in writ appeal, the division bench of this honorable court had remanded the matter to the tribunal on the ground that steel authority judgment was not considered, and even by the district division bench, a single judge and district. Whereas when the award was passed, steel authority judgment was not in the picture. Even the learned single judge has in his judgment has considered steel authority judgment. So after that, the respondent number 2, another union, they went to the apex court, Your Lordship. Apex court has set aside the high court judgment and on saying that tribunal award is absolutely correct. But the ONGC council says some legal issues have not been decided. So it was remanded back to the high court on those issues. This honorable court again dismissed their writ appeals. Against that, they again went to the apex, so it was dismissed. Then 2019, they started regularizing the service as if a fresh appointment. But this petition was left out on the ground that he is from a T-tribe committee. They use Bauri and Khetrapal together, Your Lordship. Since his name was appearing Khetrapal, and Bauri, they rejected, you are not the same person. We have placed on documents on record to show that it's the same person, Your Lordship. And if Your Lordship, I will take you to the award of.
So second time when the writ petition, when the writ appellate court
Yes.
ruled in favor,
Yes, sir.
was it headed by Honorable Justice A.S. Bopana?
Yes, Your Lordship.
Then there is a judgment already
Yes,
passed.
Your Lordship, judgment is there, Your Lordship. I have got the judgment.
Is it covered by this court, that
Yes, Your
judgment?
Lordship. Yes, Your Lordship. I gave you.
Have you seen it?
No, my lord.
Oh.
No,
The
let him
judgment is-
finish, my lord. I'll place my case.
No, no, what is there to finish? In similar matters, which court has already passed the judgment. If it is
What-
covered, we'll
Before
close
the
it.
Senate, before the Senate, before-
No, the judgment is to implement the award.
You find out.
Two copies have got. My copy has got. Thank you.
Yes.
Sorry.
So judgment to clear.
I am surprised that you are not aware of this judgment.
Yeah, my lord.
You will know it from the first paragraph. So it's the same proceeding, similarly situated employees will close it.
No, my lord. Lordship may either give me just 1 day's time to go through this judgment. Because, my lord, here the issue is Lordship may have a look at the prayer made in the writ petition.
Hmm.
Here the petitioner wants a Lordship to issue a writ of declaration, declaring that the person whose name appears in the reference and the writ petitioner is one and the same person. And thereafter, another declaration that the petitioner belongs to a Baudi community, he should be considered as an ex-chief child. My lord, whether this is permissible. under
So
the
what
writ
does community got to do with this?
that is there in the writ petition, my lord. This is the prayer made in the writ petition. And the third prayer is that he should be given the benefit from
Is
1486
the
on.
prayer binding on the court?
My lord, I am drawing your lordship's attention to, my lord. First, that there should be an exercise carried out by your lordship. Examine the facts where the facts are disputed to come to a conclusion that the person whose name appears in the reference and the petitioner is one and the same person. That is the prayer. Lordship may have a look at the prayer. It starts from page 22. I'm drawing your lordship's attention to page 23, number 1. Writ of declaration or any other appropriate writ order direction of like nature should not be issued declaring Sri B.S. Khetrapal and Sri B.S. Bauri is one and the same person. Now, my lord, B.S. Khetrapal's name appeared in the list of workers in the reference. And that B.S. Khetrapal was the person who read up to class 10 and was working from 1486. He comes up with a petition claiming that my name is B.S. Bauri. I mean, it is my only name. They say, no, the name is Khetrapal, B.S. Khetrapal. Now you are coming as B.S. Bauri. In support of B.S. Bauri, he gives a PAN card. He said, no, we are not accepting it. Then, my lord, he comes up with another PAN card showing that his name is B.S. spelling different, Khetrapal. We said, no, that spelling is different. The earlier PAN card is active. The second PAN card is also active. Then he comes up with a name, proper name, with the third PAN card. Now, my lord, our contention is that one person cannot have 3 PAN cards. That is not permissible. Another thing, lordship may come to page 100 of the writ petition. It is the annexure of the present writ petitioner in the name B.S. Khetrapal. Lordship will find it is a certificate issued by the headmaster of the school. B.S. Khetrapal, son of Ramlal Khetrapal, left the school, left the Pathaligarh High School on 15/4/87. He was 17 years old and he read up to class, he was reading at class 8. Now, my lord, may come to the list of workers
named in the reference. That your lordship will find at page
No,
45,
if that is the dispute, this is which district?
Shivsagar.
We'll ask the deputy commissioner. Sipsagar to
There is a
verify.
certificate of the commissioner.
My lord, have a look.
There is a commissioner certificate also is there.
My lord, may have a look at,
Your lordship, I before.
my lord, may have a look at the list of workers. 45.
If your lordship will see. there is a-
Just a minute, I'll come back. to you.
Sorry.
Lordship may come to page 45. Is the list of workers.
Yes, what do I do with the list? Yes.
Yeah, lordship will see that this B.S. Khetrapal was working in ONGC from 1486 till date. And the certificate shows he left school on 15487. So, my lord,
You recognize whom? B.S. Khetrapal.
yes,
B.S. Khetrapal is the recognized person.
one B.S. Khetrapal, son of Ramlal Khetrapal.
Listen, Mr. Chakravarti, according to you, who is the employee recognizable by the ONGC? B.S. Khetrapal.
B.S. Khetrapal,
So the only question is whether the petitioner is B.S. Khetrapal or not.
yes.
If it is found that he is B.S. Khetrapal.
Yes, he is B.S. Khetrapal, and because this reference document reflects that the person who is in the reference was working from 1486. And if your lordship goes to the certificate, it shows that he left school on 15487. That means on 1486, he was in school.
Maybe.
So he was in school. So this B.S. Khetrapal and the certificate with which the petitioner come may not be the same person. That is why it is a question of fact.
You are right, he may not be,
Yes,
but he may also be.
yes. So that is an exercise which has to be carried out. And with all respect, my lord, this is High Court is not the court which will carry out that exercise and give a direction that B.S. Khetrapal, the one who is named in the reference, and the petitioner is one and the same person as prayed in the writ petition. And my lord, the third prayer is that he should be given effect. I'm drawing your lordship's attention to that part also. Lordship may come to page 24. I'm reading it. Writ of mandamus or any other appropriate writ or a direction of like nature should not be issued directing ONGC to pay arrears of salary to the petitioner, which the petitioner is entitled to by virtue of his regularization with effect from 1486. So that means the petitioner is claiming that he is working since 1486, but the certificate says that he was a student and left the school on 15487. So maybe there is some irregularity. B.S. Khetrapal, whose name appearance in the list of persons in the connected reference, maybe the same person may not be. So it requires an exercise to carry it out. And with all respect, 226 court is not the court.
Who is to do it?
Well, when such is, the civil court will give a declaration that the same person, or they can approach the CGIT. That was advised. The CGIT, if CGIT which answered the reference, carries out this exercise, examining the question of fact and declares that no, the person who is named in the reference and the petition is one and the same person, then we don't have any problem. That declaration or that exercise has to be carried out by some judicial authority. It is only when such declaration is given, we'll follow the order. But to say, basically your lordship is examining our decision, whether to regularize or not, whether our decision not to appoint him is irrational, arbitrary, or unreasonable. Since there are materials to show that the person who is named in the reference and the present petition.
That's right. There's no need to repeat. The only issue is of identity. Rest of the matter is covered by the order of the.
Yes, we are not questioning we cannot, because it has attained finality.
So we'll say that he has to give proof of his identity to his.
My lord, he has given proof, but the proof is not matching. First, he comes with a document saying his name is B.S. Bowdy. We have referred in our affidavit. He files an affidavit saying his correct name, his only name is B.S. Bowdy. And in support of that, he gives a PAN card that is active. When we said no, the man who is named in the reference is B.S. Khetrapal. So he comes up with another PAN card in the name B.S. Khetrapal. But the earlier PAN card in the name of B.S. Bowdy is still active. Then he gives a certificate Lordship will come to our affidavit. We have explained. Prior to this certificate, he had got a certificate issued in the name of B.S. Bowry from the same school. Lordship may come to that certificate.
He's a very resourceful person.
Yes, my lord. And to have, my lord, three PAN cards.
Huh?
My lord,
Or maybe his lawyer is very resourceful. We don't know. That is also.
perhaps, my lord, the man who can engage a lawyer and consult from Supreme Court, he is a very resourceful person.
No, don't say that. Mr. Chaudhary does so many work pro bono also. We know that.
Lordship may come to page 138 of our affidavit in opposition.
Hmm.
This is the certificate.
All right. So what is the way forward? Mr. Chaudhary, what is
Yes,
the way forward?
your lordship, let me take your affidavit. They have deducted TDS in Bavaria and Ketrapal. I just showed this, your lordship, that page
Is
120,
another- is again,
just page 128 of the affidavit, your lordship, see.
Hmm.
128, TDS they have deducted ONGC. BS Ketrapal,
Where is your client now?
class is working. He's working in ONGC.
He's working.
Yes, he's working.
Then what are we hearing this for?
You're also for regularization, because he has not been, he's a contract service still, because the award has not been implemented.
He has got some identity number,
Yes, everything is there, you will see. This.
page number.
Page 120, they have deducted TDS in name of BS Bowry and BS Ketrapal also. That's their document.
it is not TDS, my lord.
Yeah. Just, let me speak, don't interpret. Your lordship, page 128. ONGC is there. This is BS Ketrapal, they had deducted TDS on 14 March 2022. Then next page, if your lordship will see, it is BS Bowry, ONGC, TDS deducted, same period, same date, 14 March 2022. Then next is again ONGC, BS Ketrapal, 2020, 14 March 2022. How can, if there is only one person, how can there be 3 TDS deduction from them? 3 TDS
It
deduction.
is
and
not TDS deduction, my lord.
TDS,
This is something which has been downloaded, lordship. We have.
Just a minute.
you have annexed it, it's not my document.
Who is working as BS Bowry in your company?
Yes, that is.
Is someone working as BS Bowry?
BS, that instruction I do not have because he is a contractual employee. He was a contractor's employee, my lord.
Acha, do you have a person by the name of BS Ketrapal working in your company? You must be having because you have deducted TDS.
No, it is not tax deduction, my lord. That is what I am trying to explain, my lord.
Hmm.
This is, my lord, if this is TDS, then how can be deducted against 3 persons, my lord?
No, whatever it is, there is
It is-
some deduction by.
No, my
ONGC.
lord, it is not deduction. It is once a PAN card is given, it can be examined in the official website, whether this PAN card is active or not. That is what we have explained in our affidavit in reply. May I draw your lordship's attention to when
Is there any person working in ONGC in the name of BS Ketrapal?
Let them find out.
Yes or no?
he must be working with a contractor.
He has been regularized, he said.
He has been regular, if he has been regularized, then why is the prayer?
No, your lordship,
My lord.
let me clarify the situation, because he's trying to.
Call him. When can he come? Let him come to the court. Release document.
Yes, sir.
We'll see. Let him remain personally present.
Your lordship.
When?
In April, month of April.
Huh?
Month of April, just,
Month of April, you choose the date.
your lordship. Big holiday is there, then your lordship can have it on 25th of April.
25th of April.
Yes, your lordship.
On that day, the petitioner will remain personally
I-
present with all his credentials.
Yes, sir, that I.
We had heard Mr. P. Chaudhary, learned counsel appearing for the petitioner, also heard Mr. S. Chakravarti, learned counsel representing the respondents. Although the primary dispute involved in this proceeding touches upon the validity of the order, award of the learned tribunal, it appears that there is a ancillary dispute arising in this case as regards the true identity of the writ petitioner. Full stop. According to Mr. S. Chakravarti, learned counsel for the respondent, the person BS Ketrapal is different from BS Bowry, and until and unless the identity of the petitioner is established beyond doubt, the question of granting any benefit under the award, if any, would not arise. Full stop. Mr. Chaudhary has advanced weighty arguments in support of his claim that B.S. Khetrapal and B.S. Bauri are one and the same persons. Full stop. However,
I have placed documents also there.
by referring to the documents placed on record, but the learned counsel for the respondent has persistently refuted such arguments. Situated thus, this court is of the view that the petitioner should be asked to remain personally present before this court, along with all his credentials, to answer the queries of the court in the matters. Full stop. In view of the above, the petitioner shall remain present before this court on 25th of
Yes,
April 2023. Let this matter be listed again on 25.
Your lordship, I direct them also to find out this thing, whether they do.
Yes. In the meantime, the respondents counsel to also inquire as to whether any person by the name of B.S. Khetrapal alias B.S.
Any other person.
Any other person by the name of B.S. Khetrapal alias B.S. Bauri is working either directly under the ONGC or under any of its contractors, and if so, necessary particulars along with supporting documents be also placed before this court on the next day. Registered to list the matter again on 25th of April 2023 as a fixed item.
Deeply appraised.
My lord, item number 5 is slightly different. Here only trapezoidally irregular.
Item number 5.
Right.
Sure. This order will be passed in item number 6.
Four.
Okay, item 4. What is item number 5?
I say number 5, my lord, kindly come to page number 55, lordship. This is the list, lordship, petitioner association has submitted before the consultation officer, my lord. Page number 56, my lord, petitioner name is reflected as Binod Chandra Bora, my lord. Page 56.
Just a minute. So what is this Bindu Chandra Bora? You give him the appointment.
My lord, in the reference, my lord, when the matter was referred by the government, his name appeared. I do not know whether it is his name. One person, Bindu Chandra Bora. Now, we do not have any employee in the name Bindu Chandra Bora because they are all contractors' employee. They worked under a contractor. The person whose name appears in the reference is Bindu Chandra Bora, which your lordship will find at page 57.
But that's been clarified. There's a mistake, typographical
Yes, my
mistake.
lord. Now that the name typographical mistake, it is a reference made by the central government. So any error or mistake.
We'll clarify. 226 court, we have the power.
One thing, my learned friends, referring, they are working under the, they have been refused by the tribunal. They are SAM and they, because award says clearly in both the matters that this is a SAM, there is no contractor itself.
Exactly.
That is
why they were.
That's why the award said direct employee, they are direct employees of ONGC. The award, if you actually see it's written there.
So my lord, they were working under a contractor.
So my learned friend cannot say that they were working under a contractor every time to prejudice this honorable court.
All right. Yes.
Now, my lord.
We are issuing a mandamus in next 5 minutes.
My lord.
You can argue. See, people are being harassed. Don't harass people.
No,
like
no,
this.
I'm not, my lord. That is
He's
why
a
here
poor
it is-
man. He's got an award in his favor.
My lord,
What
it is.
Bindu Chandra? Has any Bindu Chandra Bora come to
My
you?
lord, may I point out, my lord? May I
Yes.
point out? This matter was taken out by the labor authority. We informed the labor RLC. That you carry out the exercise, you make the necessary correction. RLC is not doing.
So we'll make the correction. What is the problem?
If your lordship corrects it, otherwise, my lord, as a department, my lord,
Hmm.
when a person's name,
So I thought we'll dictate in 5 minutes, we'll dictate in 50 seconds now.
my lord,
What is there in it? The only difficulty arises due to the typographical error. Already RLC has clarified this is a typographical error. There is no one called Bindu Chandra Bora who has come to you. The petitioner is pursuing his remedies. So he'll be this Bindu Chandra Bora will be treated as a typographical error, and it is the petitioner who should be given the benefit. That's all. What else is there in this case?
and my lord, the referral authority, the union government is also not a party, my lord, here in the
Mr.
referral.
Chakraborty, you have your mighty resources. These are poor people. They just got something from the tribunal.
And my lord.
Don't show
we
them
can-
law.
My lord,
They
why?
have gone to the apex code also, everything has to be done. Everything.
Perhaps my
Errors
friends, my lord, my
If we
friend's
start
case
it,
is
nothing,
over.
your lordship.
My friend's case is over. If he is not appearing in this
Alright.
case,
I appeared in this matter also. He should not say that. I appeared in this matter to the apex code.
no, you appeared before the matter in the apex court, but,
He cannot say I am not.
Let me dictate the order. Let me-
and my lord,
Hmm.
we have examined our records.
Hmm.
There are 3 B Boras. One B Bora, father name is different. One Binod Chandra Bora,
Hmm.
father is this. Another person, Binod Bora, whose father is Bimal Bora. And my lord, they have certain passes. So that is why we requested the,
Oh, the person Binod Chandra Bora, who is the son of Jogeshwar, late Jogeshwar Bora.
yes, the reference, my lord, in the list of workers, unfortunately, the name of the father is not mentioned, my lord. That is why the problem started.
But
It-
has any other person by the name of Binod Chandra Bora or Bindu Chandra Bora ever
No,
approached?
no.
court?
No,
And the award is of which year?
of 19, reference of 99, and the matter has been recently finalized in, before the Supreme Court.
Which year?
Last,
High
Supreme Court and High Court.
2012, that award was a 2002, 2000 year. Then it came to single judge, the single judge decided, and division.
Award is of 2000.
Yes, sir,
Yes.
2000. Today, they are on the verge of retirement.
So has anybody else claimed under the award except this petitioner?
No,
Then what is it? We'll clarify it.
because the department also doesn't want to subsequently, if something
All right,
happens.
we'll clarify.
Yes.
We'll indemnify you. That's
Yes,
all.
my lord. Otherwise, the officers, I talked to the officers and I asked the same thing. He said, we cannot take the responsibility if something
All right,
happens.
heard Ms. S.G. Burwal and counsel appearing for the writ petitioner. As Sutia, counsel appearing for the writ petitioner also heard Mr. S. Chakraborty, learned counsel representing the respondent numbers 1,
One.
2, and 3.
No, I'm not representing. Then apuni kenake ঠিক থাকে? Apuni Assam হরে central নহয় না?
1 and 2. 1 and 2, is it? You are appearing for 1 and 2?
1 and 2, my lord.
Yes.
He cannot appear. It is a central. He is for Assam. That is what I am saying.
You are debarred from appearing.
Central.
All right, Ms. S. Burwal and CGC is present on behalf of the respondent number 3. Full stop. As per the case projected in the writ petition, the petitioner herein was one of the
C2.
beneficiaries of the
In
award
bracket T.
dated
Not knowing how to
18/12/2000
appear.
18/12/2000 passed by the Learned Industrial Tribunal, Guwahati, Assam, in connection with reference number 12 bracket C bracket close of 1999. First up, despite the award having attained finality on being affirmed by the Honorable Supreme Court of India, and notwithstanding the fact that several other similarly situated employees have already been given or are in the process of conferring with the benefit under the award, the petitioner has been kept knocking at the door. The solitary reason for that is owing to a confusion arising out of the misspelling of his name in the award. Full stop. It appears that in the final award issued by the Learned Industrial Tribunal, the name of the beneficiary has been shown as within quotes Bindu, Bindu, Chandra, Chandra, Bora, Borah, whereas the name of the petitioner is Binod Chandra Bora, Sri Binod Chandra Bora, full stop. Ms. Chutia has referred to the materials available on record to contend that even the regional level commissioner, that is the respondent number 3, has clarified with the ONGC authorities that the appearance of within quotes Bindu Chandra Bora was a typographical error, and the actual name of the person is Binod Chandra Bora, who is the read petitioner in this case, full stop. It further appears that Sri Binod Chandra Bora is the son of late Yogeshwar Bora and is a resident of village Palengi, Dhyan Gaon, in the district of Sipsagar, Assam. Full stop. Mr. Chakravarti submits that due to the confusion arising out of the error in projection of the name of the petitioner in the cause list, the ONGC authorities are not in a position to confer the benefit of the award to the petitioner unless it is clarified that the
And there is no Bindu Chandra Bora.
that there was a mistake in spelling of the name of the petitioner in the award, full stop. It is also the submission of Mr. Chakravarti that there is no person by the name of Bindu Chandra Bora in the role of ONGC or any of its subsidiaries, full stop. After hearing the submission of learned counsel for the parties, this court is of the unhesitant opinion that it is the petitioner Binod Chandra Bora who is the beneficiary under the award, but his name has been wrongly spelled as Bindu Chandra Bora in the award, full stop. What is also to be noted here in that although the award was passed way back in the year 2000, no person in the name of Bindu Chandra Bora has ever approached the respondent numbers 1 and 2 or any other forum claiming any benefit under the award, full stop. Situated thus, this writ petition is hereby disposed of by providing that the petitioner would be treated as the beneficiary under the award dated so and so, as against the misspelled name of within quotes Bindu Chandra Bora appearing therein. In the event of any claim arising in future by any other person in the name of Bindu Chandra Bora, the petitioner, the respondents 1 and 2 shall stand indemnified and the matter will be appropriately dealt with by the court. With the above observation, the petition stands closed. Yes.
Item 6.
Yes, yes, you take it from here. Give him that copy. You are not giving him benefit. Why should he give you judgment?
I should take the reference and give it.
Give him the award benefit. Yes, yes, Mr. Manan.
Yes.
First of all, how long?
Not much longer.
Approximately.
This is a matter with regard to a promotion matter where this
Short matter.
Short matter, because this honorable court has interfered with the promotion, setting aside the promotion earlier. Then that part is there. Then secondly, they have again thereafter have again promoted the person. With regard to the promotion, we are not against it, but have again put him back to the place, to the point where this honorable court has interfered, that is giving him retrospective effect from the date of the date when he was earlier, his promotion was interfered. This is the short point, Your Lordship. Whether that can be
how much time will you take?
15-20 minutes, Your Lordship.
This court is only for the first half today. You will be depriving your other colleagues. Decide on that. We'll come back in 5 minutes. And if you want, then we'll
I'll
do
make
it.
it as short as possible.
Yes.
If required,
Item 6.
Lordship. Just I'll point out, the Lordship feels that it may not be possible today, then fine. Just 2 points, page 130, 114. Or Lordship can take up page 117 onwards. I will not go to the first page. Page 117 is the order of the honorable court, where the earlier promotion was set aside. So Your Lordship will kindly turn to page 132. 132 is the order, operative part.
Yes.
Paragraph 17. I'm not going to take very long. In connection with, there are some many writ petitions, Your Lordship,
This is with connection with this particular person. In connection with WPC number so and so, the respondent number 1 to 3, that is rubber board, has not been able to show that in order to promote the private respondent number 13, this is the present private respondent, you see, namely D. Suresh, any DPC or supplementary DPC was held. Hence, the challenge to the promotion of the respondent 13 in WPC so and so is sustained, and as such, the impugn OM dated so and so in respect of the respondent number 13 therein is set aside, and by making the interim order so and so pass, making absolute. Now, what has happened? This is the order passed, it has been set aside. Facts, your lordship, the long facts. If I go through the facts, it will take a long time. So I'm coming directly to the promotion. The promotion was done illegally without DPC, and therefore it was set aside by this honorable court. Now, what they did, your lordship, the next page number 134. Page 134. This is the impugn, first impugnment. This is on 1/11/2021. After the judgment, that is on 22/4/2021, after 6 months, they passed this order. D. Suresh, now this is the representation filed by D. Suresh. On the representation, this was done. Dated so and so has requested to restore his seniority based on his earlier promotion order dated so and so. As per the judgment dated so and so, the Honorable Guwahati High Court. He was promoted to the post of development officer against the SC reservation vacancy wide OM dated based on the select list of DPC dated so and so. But due to the stay order dated so and so of the Honorable Guwahati High Court in WPC so and so, this race was unable to join duty in the promoted post. Later, wide OM dated so and so, Sri D. Suresh was promoted to the post of development officer in SC reservation vacancy, but not reinstated his previous seniority. A review DPC was convened and the committee examined the case in detail. The committee recommended to reinstate the seniority of D. Suresh in the post of development officer as in the seniority list of DPC held on so and so, by which he was promoted to the development officer. Accordingly, the seniority of D. Suresh in the post of development officer is reinstated with effect from 14/11/2014, the date interim order of the Honorable High Court of Guwahati WPC so and so for maintaining the existing status quo, and his position is placed between so and so as per the then existing seniority list. The monetary benefit in respect of so and so will have effect only from the date on which D. Suresh assumes duty in the promoted post of development officer, that is so and will not confer right or claim other than the emoluments attached to the post. He will be eligible to be considered for promotion to the post of deputy RPC considering the residency period with effect from 14/11/2014. So he has been given everything, not only the promotion, that too from the date. That date, your lordship, it was illegal. Now they have held the DPC. We are not on that. Because DPC is held, he can be entitled to the promotion with effect from the prospective effect, but cannot be with retrospective effect from the date when the court found that his promotion was illegal. This order has given him not only that, now they have given a second leg to him, is that subsequent promotion to the RPC will also be considered from the date of 2014 for the post of RPC. 5 years experience in the post of DO is required. So if it is given to him in 2014, he gets it 5 years now. In 2022, it was in 22. Then, your lordship, subsequently what happened after we filed the case, there is an interim order on this by this honorable court saying that the honorable court order has been violated, so it was stayed. But the date of order, by the date of the order, he has already given another promotion, so we filed a contempt case also. That is there. That is a separate part. But this order itself is violated. With regard to the promotion prospective, I have nothing to say. But how can you give him back all the seniority when your initial promotion was wrong? You did not hold any DPC. You put a person in promotion, and that too, if I go to the facts of the case, your lordship, he is much junior to me from the very beginning. There are cases, your lordship, I will show where if I go back to the history of this case, which were already asked before the court, before the learned single judge in the other cases, and there is a pendency of the cases before the honorable division bench with regard to the other cases which has been dismissed by the single judge.
So, Mr. Manan, are you saying that the respondents are in contempt of the court's order passed earlier?
This order seems to be an order which is invariably your lordship can interfere under 226.
No,
But contempt is with regard to the order passed in this case.
In which case? This case?
Yes.
Which order?
Because
Contempt-
subsequently, after this order was passed, this order was, your lordship, this court passed an interim order.
Which order has been violated according to you?
In this case, this order has been 1/11/2021, page 134.
Page 134.
134.
Is not a court order. It is
It
their
is
order.
not a court order. It's not a court.
Is
order.
there any violation of any court order?
No, that subsequent order, when this court, we moved this matter in the first motion stage,
Oh,
there's an
Mr.
interim order.
Pradhan,
passed.
I'm asking you, is there any violation of any court order here?
Yes, the first interim order.
Which is that order?
Yes, no, it no. A2 case order to be na. First order.
Which order has been
Purana order to be. Your lordship will kindly turn to the order that was passed in 7/1/2020. We moved the matter. Your lordship is already there with the order. Contempt case we have not annexed with this. First day, your lordship, when it is moved, this honorable court has passed an order staying the operation of 134. This 134, after being stayed by this honorable court,
But there is no violation of the earlier judgment of this court, which is
the earlier judgment is at page that 132 that I have.
case number 7777 of 2016.
Yes,
That judgment, which was
that
rendered-
judgment along with 77, there are 5815,
Ah.
another case, and this particular case.
Is there any violation of the order, judgment and order dated 23rd of March 2021?
23rd of March,
Yes, 23/3 to 2021,
Yes.
page 124.
yes.
Has
This
this order been
order-
violated?
This order is, para 17 has been violated by the order at page 134.
So have you filed any contempt case?
No, this is, lordship, how this has been violated, I have shown. The court has set aside the promotion.
Hmm.
Set aside the promotion.
Hmm.
We are challenging that subsequently they have a DPC.
Hmm.
Here I am not challenging the content of this order. I am challenging that the order court has set aside a particular order. For example, the promotion was set aside being illegal. Now you give a promotion. My case here is that your retrospective promotion is being challenged in this way. I am not challenging the order of this order. Retrospective.
Mr. Manan, this matter will take some time. You have just given the synopsis.
But
can't
if I
pass a
go back
judgment.
to the facts
You
of
have
the
to
whole
go,
case,
you have to go, you have to go.
then it will take.
You are
obvious.
talking about retrospective and how can you not go back?
Then I have to go back to the first promotion. Then, lordship, I leave it to your lordship of date, because
You have it after the Bihu vacation. Choose a date. Before Bihu, it will be difficult. In any case, is it hampering your client immediately?
because what happened, this respondent, I think, the private respondent would be retiring. May, in the month of May. So, yes, if it is before that, it will be better, because he's
What
getting
will-
all the benefits now.
No, if he retires, if the writ petition is allowed, then his benefits will be.
At best, his
Okay.
benefit will go, that is fine, but at least if it is done when the matter is alive.
No, that these are all ego trips
Because
between
what
clients.
is another part is that I have not mentioned. The other matters, 7777 and the 5814.
Hmm.
These two cases are on appeal before the honorable division bench. These are also on appeal.
Hmm.
There, this part is not taken care of. So even if that part is in our favor also, then this part will still remain. That is why your lordship will have to take a call on this. And make it after the Bihu, no problem. And sometime.
We'll have it on 2nd May. I heard Mr. Y.S. Mandan, Learned Counsel for the writ petition, also heard Ms. M. Devi, Learned Counsel.
Can it be on 27th of April, your lordship? if possible?
April will fix it, but only to fix another date in June. Because what happens is, there are already many matters fixed.
Yes. Okay, lordship, at 2nd of May.
Also heard Ms. M. Devi, Learned Counsel appearing for response numbers
2, 3 and 4.
2, 3 and 4 and Ms.
P. Fergari for Union of India.
P. Sargari for the response number 1. Any private respondent here? Who's appearing?
Private respondent, Mr.
I think Mr. S.R. Rabha.
Rabha was appearing all throughout here.
One has appeared for the private
Mr.
respondent,
Rabha appeared here.
although the name of the
His name is also
shown in the private respondent number 5. Although the name of the council is duly reflected in the cause list. Be that as it may, since the matter pertains to claim of the petitioner, the matter pertains to a challenge to the promotion of the respondent number 5 with retrospective effect. This matter cannot be decided without hearing the respondent's counsel. In order to give one more opportunity to the respondent number 5 to appear and defend his interest, let this matter be listed again on 2nd of May 2023 at the fixed item.
lots of place.
Maybe legal lordship.
Yes.
Like this case is challenging the subsequent alteration of my date of birth. Lordship. Earlier your lordship had my matter and on lordship 23rd February. Findings have been recorded lordship with observation lordship. Lordship may kindly come to the order dated 23 February lordship.
Yes.
Lordship, this is a subsequent alteration, Lordship. And Lordship, the authority has no right to alter my date of birth, Lordship, without making any inquiry or without issuing any notice, Lordship.
So your client has retired already.
Lordship, no, Lordship, he has retired, Lordship. Though he has not really formally by issuing any letter, Lordship. But he has no role, Lordship.
School certificate is the only basis.
Lordship.
You have to follow that.
Lordship.
By following the school certificate, if he retires, he retires. If he doesn't retire, he doesn't retire.
Lordship.
PAN card is not a basis. That's the law. There is a recent judgment by the division bench You are not aware of that.
Lordship Supreme Court judgment, I am aware, without.
But this division bench, our division bench, last month only there is a judgment. You are not aware. Only school certificate.
School certificate, Lordship.
But if you don't give me the judgment, I cannot dictate the order today.
Lordship,
Lordship, actually petitioner himself is also confused. What is his actual date?
Let everyone be confused. Only date of birth that will matter is school certificate.
Lordship.
That there is a judgment. Get the judgment division bench. I was a party to the bench.
Lordship.
Honorable Chief Justice and me, myself. You get the judgment. You have to tell your authorities. Because these confusions will keep arising otherwise. PAN card, this card, that card, no, nothing. School certificate, whatever the age given, whether it is beneficial or adversary, doesn't matter. It has to be followed.
Okay.
Can you get the judgment?
I can Lordship.
On Wednesday, we'll post it then. We'll pass the order on Wednesday.
Obliged, Lordship. Lordship, is it reported, Lordship?
No. You ask the Chief Justice.
I am sorry, Lordship.
Mr. So-and-so for the, it's for the petitioners, Mr. Aram Das, then SC for NC's Autonomous Council, Ms. MD Bora Lanet, Government Advocate Assam, and Mr. P. Naik, and Standing Council for the Finance Department are present. You see, the issue here is a date of birth related dispute. This issue keeps cropping up. So recently there is an order of the division bench. It was in a habeas corpus petition. The multiple date of birth were projected, some through PAN card, some through this, even the, so the first school living certificate or school certificate, that will have to be taken as correct. That cannot be changed. Unless there are cogent materials. If 2-3 different date of birth is projected, you have to go by the school certificate.
In this case, it's a transfer certificate, not HSLC certificate.
Whatever the school authorities give, that has to be taken. Right, wrong, that has to be taken.
No, that judgment was on the point that HSLC certificate is considered. as
No,
a-
there was also transfer
But
certificate.
so far as transfer certificate.
Let us see what is that.
Not-
On the request of Learned Council for the parties, let this matter be listed again on Wednesday, that is 22nd, as a fixed item, so as to enable the Learned Council to produce the division bench judgment recently delivered on the point of document to be accepted as the basis of date of birth of the claimant.
Item 8.
Item 8, Lordship, we have received the instruction, Lordship. Preparation of affidavit is going on.
What is the matter about?
It's about,
Lordship, we have challenged the Lordship inquiry proceedings as well as the
Let him file affidavit. Mr. H. Chakraborty, Learned Council is present for the petitioner. Mr. P. Naik, Learned Departmental Council submit that instructions have been received and therefore he will be granted 4 weeks.
3
time
weeks,
to-
3 weeks.
4 weeks, go to view.
Lordship, yeah.
4 weeks time to file affidavit. Prayer allowed. Let the affidavit be filed within 4 weeks by furnishing advance copy upon the petitioner's counsel. Magistrate will list the matter accordingly.
Obliged.
Was not pressed. Item 9.
May I please, your lordships. Your lordship will kindly see your lordship's last order, that is 28/2/23. Lordship.
Yes,
Lordship, I received the response from the chief electrical inspector, Lordship, but from the government, Lordship, yet have to receive, Lordship, from the government. My lord, I don't know how long they will take time, my lord. I'm retiring in August.
You are for whom? Respond number 5. All right, what I'm doing is I'm disposing of this writ petition today itself. I will say that who is the authority, who is the appointing authority here?
Lordship, here for
Oh, Mr.
Deputy
Goswami,
Secretary-
as always, you are not clear about what you want to say.
Deputy Secretary, this
We'll send
notification.
it back to respond number 1
Lordship.
to examine whether the appointment of the respond number 5 is strictly in accordance with the rules. If they find that it is strictly in accordance with rule, matter ends. Otherwise, if there is any dilution or relaxation of the rules for respond number 5, similar treatment will be given to petitioner and the order of appointment will be reviewed and giving adequate weightage to the seniority and experience of the petitioner, a fresh order to be passed within 1 month, appointing a member secretary. That is the order I am passing now.
Lordship.
And this exercise will be concluded by the respondent number 1 within 4 weeks from the date of receipt of a certified copy of this order.
Lordship.
Mr. Gogoi.
My lord, it is fine.
All right, heard Mr. D.R. Gogoi, learned counsel appearing for the writ petitioner. Also heard Mr. J.K. Goswami, learned counsel appearing for the respond numbers, Government Advocate Assam appearing for the respond numbers 1 to 4, and Mr. R.J. Das, learned counsel for the respond number 5. First of all, the controversy involved in this writ petition is pertaining to the appointment of the respond number 5 as the member secretary of the Electrical Licensing Board bracket ELB. First up, according to petitioner, he is senior than the respond number 5.
Senior for 17 years.
He is 17 years senior in service as compared to the respond number 5, and is also due for retirement in the month of August 2023. First up, however, now although the petitioner was earlier appointed as member secretary of the board, yet in this occasion his candidature and seniority was ignored by the authorities and the petition merely on the ground that he did not possess a bachelor's degree, and the respond number 5 was appointed, although even she did not meet the requirements of the rule. Full stop. Taking note of the submissions made by learned counsel for the parties, this court had passed the following order on 28/2/2023. You have to quote the order. Full stop. Today, when the matter is called up, Mr. Goswami submits that he has received some instruction from the chief electrical inspector cum advisor, but he is not authorized to appoint the member secretary of the Electrical Licensing Board. Full stop. According to Mr. Goswami, instructions from the government is still awaited. Full stop. It is not in dispute that the reason why the petitioner was not appointed as the member secretary of the board was on account of the fact that he did not possess a bachelor's degree. Full stop. However, what would be pertinent to note here in that the requirement of holding a bachelor's degree by the inspectors was introduced by the but however, what is to be noted here in that at the time when the petitioner was recruited, having a bachelor's degree in electrical engineering was not a mandatory qualification norm. Full stop. Moreover, there is no dispute about the fact that
It was, Lordship.
then how was he appointed?
But there have some proviso is there. It is phase 61 in the writ petition, Lordship. It is annexed, Lordship. Provided that the appropriate government may, for a period of 7 years, commencing on the date of Indian Electricity Amendment Rules 1986 are brought into force, also appointed a person processing recognized diploma in electrical engineer.
All right, you take down. It is also not in dispute that the writ petitioner was appointed as electrical engineer. He was appointed electrical engineer or inspector.
Inspector, Lordship.
Electrical inspector in relaxation of Rule 4 of the Indian Electricity Rules 1956, despite the fact that he did not possess a bachelor's degree. First up, after rendering long years of
My lord, your one paragraph your lordship will add, my lord, earlier there are other officers, one Ajit Kumar Gogoi. Whether
No, Mr. Gogo, you please take your seat. These are things that have already been added. Long years of service and is presently on the verge of his retirement. First up, it is also not in dispute that the petitioner was earlier allowed to function as the member secretary of the board. First up, since the rules have been diluted to accommodate the petitioner, the claim of the petitioner prima facie appears to be legitimate. First up, considering the fact that the state government is yet to come up with its response to the allegations made in the writ petition, and considering the fact that the petitioner is due for retirement in the month of August 2023, I am of the view that the scale of justice will hang in balance if the departmental authorities are directed to review the appointment of the writ petitioner of the respondent number 5 as the member secretary, and thereafter pass a fresh order as per the guidelines provided by this court. Full stop. As such, the matter is remanded back to the respondent number 1 to carry out a review of the appointment of respondent number 5. If it is found that the appointment of respondent number 5 is also in relaxation of the rules, then and that the petitioner was earlier appointed and allowed to function as the member secretary of the ELB, then in that event, the respondent number 1 shall consider the candidature of the petitioner as well as the respondent number 5 and pass a fresh order appointing member secretary of the board by bestowing equitable consideration to the candidature of both these candidates. First, in doing so, the respondent number 1 shall bear in mind that the petitioner is due for retirement after that the petitioner is more than 17 years senior to the respondent number 5 and is also due for retirement in the month of August 2023. Full stop. The exercise as directed herein above be carried out and completed as expeditiously as possible, but not later than 6 weeks from the date of receipt of a copy of this order. The petitioner to furnish a certified copy of this order before the respondent number 1 for necessary compliance. You please produce a certified copy of this order. Yes.
what I was trying to point out.
That has already been mentioned, that he has already functioned.
My lord, prior to that, one Ajit Gogoi, who was diploma holder, he was also given this job. I read it.
Add one more line. It has also been,
Page 11, page 11.
it has also been brought to the notice of this court that prior to that, a person, namely Sri Ajit Gogoi, who also did not possess a bachelor degree in engineering, was allowed to function as member secretary of the board. After the petitioner was earlier allowed to function, after that you add this like, yes, we have added it.
Oblige, your lordship.
Yes. Added that line, Mr. Gogoi, that line has been added.
Oblige, your lordship.
Happy, anything else?
I am very happy.
All right. If we are happy, we are happy.
Today I will eat more.
All right.
Your lordship, this is the matter pertaining to the removal of the RPF constables.
Removal of what? RK?
RPF constables,
RPF constable.
yes.
What happened? Constables are being removed.
Yes, your lordship.
Why?
Your lordship actually, on the last date, your lordship has fixed the matter for disposing of this writ petition.
You filed affidavit.
Yes. Yes, she has filed.
Removal without holding any inquiry.
Any disciplinary proceedings?
Acha, recently there is a judgment of this court. Have you got that judgment?
No, your
On
lordship.
311. Same thing was done. Person was, he was a CISF personnel. He was removed without an inquiry. This court has set aside that order of removal. Why don't you get the judgment? Then we'll pass an order.
Your lordship, the main problem of our High Court website is in the Supreme Court, we get a separate column for latest judgment. That is not there in the Guwahati High Court website.
All right, we'll do something about it.
So that at
But,
least the young juniors or young lawyers, they can have the access to that particular.
No,
column.
that's a good suggestion. We'll work on that. Huh? Is it there?
No, but there are only selective judgments. But
All right, for now, you get hold of the judgment and we'll dispose of this matter accordingly. There we have discussed about some law.
yes,
Tulsi Ram Patel's case,
yes,
etc. we
yes,
discussed.
your lordship.
So if it is covered under that.
It is covered. It is covered. Even on that strength, your lordship may dispose of this writ petition as well.
That's correct, but once this court has passed a judgment, we should refer to that. No?
Yes.
So, why didn't you hold inquiry?
Lordship, under RPF rule, 161(2), sub-rule 2, under this rule, he has been removed from service without holding inquiry. And
That is his
reasons
case,
were-
but why have you
yes,
done it?
reasons were recorded in the order, Lordship.
What is the reason? Let us see.
Page 70,
Page 70.
yes, last para, from last.
Yes,
May I read, Lordship?
yes, please.
TSK arrived to the conclusion that the above named staff have been unlawfully dealing with contraband goods, which is against the ethos of uniform and assigned duties, and also violates the very purpose for which they were appointed. Therefore, by exercising his power under Rule 161(2), Sub-Rule 2 of RPF Rule 1987, TSK has imposed the penalty of removal from service to Constable Sri Ayush Tomar. Sri Ayush Tomar agreed with the above punishment imposed by TSK and preferred appeal before the appellate authority, that is CSC NFR on 5/6/2020, who has not found any convincing reason to interfere with the order passed by the disciplinary authority, hence the appeal was rejected by appellate authority. His appeal was rejected, Lordship. And
What do you say about the recent judgment of this court on 311? The court has said on certain these grounds it cannot be dispensed
yes,
with.
I have to go through the judgment, Lordship. I have not got it.
You cannot.
Yes.
Something what is not reasonably practicable, that has been discussed in the judgment. Oh,
Yes.
he's murdered someone, so no, will not do it. He's done this, will not. That's not the ground. The ground should be such that it is not possible to hold. If you move contraband, this is definitely possible. Lodge an FIR, let the matter be handled by the anti-corruption narcotic branch.
Yes.
This is not a ground to.
Even Captain M. Paul judgment also is very specific to this context.
Yes, yes. What is your answer? 27th will dispose of. Go. You also go through the judgment. 27 March.
27 March.
Yes.
Your Lordship, I will not be there.
So when will you be there then?
Your Lordship may fix it on 20,
28 or 29th March.
no, prior to 27, Your Lordship.
All right. We'll fix it on 21st.
Yes, yes.
Both of you go through the judgment, get me a,
21st.
yes, 21st. I heard Swati Bidhan Barua, learned counsel appearing for the petitioner, also heard Mrs. Barua, learned CGC on the request of the learned CGC. This matter stands adjourned till 21/3/2022 so as to enable her to examine the latest judgment of this court and address arguments. List this case again on 21/3.
Only
21
one request, if Your Lordship may give us the citation.
citation you'll find out from the website. It is on 311.
Okay.
It is not even a month old.
Fine.
Okay.
Your Lordship, obliged.
Item number 12 to 18 is wrongly listed. For hearing item 20.
Who's there in item 20? You can finish it off.
No, Your Lordship, I
Then
understand.
we'll
that
not start.
Your Lordship, we have some paucity of time today.
Yeah, because this bench is not
Yes,
sitting in
yes, yes.
7 days.
The 5 matters, effectively, Your Lordship had heard in small detail, so Your Lordship will take some time though. I cannot dispute that.
You can finish.
Yes, yes, absolutely, Your Lordship, I cannot.
I don't want to make it
No,
part
no,
of.
that is fine.
Then when? Do it after Bihu.
I'll leave it to Your Lordship. The matters are still right, though.
Huh?
The matters are still right, even after 10 years, they're still in service. So I'll leave it to Your Lordship to fix the date, but
Matters are still live,
live, ripe and live.
ripe and live,
Yes.
but with oxygen support.
Some of them
Yes.
already, I think, retired.
But some of them, one has retired and 2 of them are still in
Because they are
service.
senior,
It's a seniority dispute.
So what has happened is, Your Lordship, there was a process by the APSC for 18 posts. There are 18 selected candidates. Thereafter, without the APSC being involved in the same course, there are 15 other candidates who were enrolled. They were brought on par with the regularly selected candidates. And effectively, what has happened is that they have secured a march over the petitioners who were legitimately selected. So that is the basic issue. There's another smaller issue here, which is that the APSC merit list was not finalized, the final select list. But even if Your Lordship decides on that matter, the other aspect as to those 15 candidates who similarly walked in after having failed.
So last day I said, I asked you about Rafiquddin's judgment.
Rafiquddin, I went through the matter, Your Lordship. In fact, in Rafiquddin, what has happened is that the matter pertained to a set of rules which are violated. And the 40% aggregate marks was lowered to 35% aggregate marks for 2 individuals, for subsequent inductees. That matter, the facts of the matter in Rafiquddin, Your Lordship, I've gone through the matter in detail, will not be applicable in this matter because there's no sanctioning of any lowering of parameters or tests.
No, Rafiquddin case, the ratio is that people who have entered the service
Yes.
divorce the rules.
Yeah, they was the rule.
They cannot claim seniority over
Yes,
persons who have
yes,
come.
that I have gone through here.
So why do you say it is not? Law is what is
The law is applicable. In fact, what has happened, Rafiq, in what I gone through, your lordship, is that
You've
the
gone
selection-
through it hurriedly.
No. I've gone, the selection criteria were lowered.
How many times have you read the judgment?
I have read the judgment
Only
once, but I have gone through portions.
Or you have read the head notes?
No.
Okay.
So the matter is slightly different because there were no fixed specific rules for selection. There was an advertisement which laid down the criteria for selection. The selection was done. There were candidates who were not selected. Those candidates at a later point in time preferred a representation before the authorities. The authorities, without the sanction of the APSC, inducted them in the course. The first lot of selected candidates, they were already enrolled in service. They had already gotten their first pay. Thereafter, the private respondents joined. And now, based on the marks that they obtained while graduating from the college, that was held as a basis for promoting them. I'm still in the lower rung, even though I was in the merit list, my standing was 1. And there were candidates, private respondents who were not within those 18 appointees. They stole a march, now they're senior to me, they're about to retire also in some time. I am still here in service for a shorter while. My other colleague had retired. The issues are still right, that's why I made that submission. The Lordship will fix a date for the matter to be heard in detail. There are quite a few annexures also. All the annexures need to
You
be.
decide on a date.
I'll leave it to your Lordship. I'll leave it to your Lordship. Yes, I'll leave it to your Lordship.
So and so for the petitioner, so and so for the respondents. Mr. T.C. Chutia, you are for respond numbers 1, 2, so respond numbers? 6, man. Respond number 6. Mr. T.C. Chutia, additional senior government advocate Assam is present on the official response. As prayed for by learned counsel for the petitioner, this matter is directed to be listed again on 11th of May. Huh?
11th of May.
Yes.
Okay, yes, quite a part that.
You will not even realize suddenly 11th of May will come.
Item 25.
Lordship, on behalf of Mr. A.K. Projector, Lordship, actually this is part heard matter heard by the Honorable Justice Mr. Saikia, sir.
It is submitted at the bar that this matter is part heard before another bench. Bracket. Justice Soumitra Saika J. Register to verify and list the matter before the appropriate court for hearing.
Item 26.
My lord, item may be fixed, my lord, 25 item on next 31st.
The part heard matter will be fixed automatically, it will come.
Item 26.
None appears on call, matters to adjourn for 4 weeks. Ms. M.D. Boral, I mean, government advocate Assam is present on behalf of the respondents.
Item 27.
You can hire Mr. You can hire in selection code number 3, madam.
As paid for by learned counsel for the petitioner, these matters.
Dismissal for service, my lord. Maybe after some time, my lord.
Sorry,
After some time, maybe taken up.
after some time, how much time? This bench is
5
not.
minutes
sitting.
after 5 minutes.
No, we can't take up. 4 weeks, yes.
Date may be fixed, my lord.
After 4 weeks. it'll come.
Item 28.
So give a date, we can't hear these matters. If anybody comes, give a date. Chalo, call the
Item 20.
28, 29, 30, 31, 32.
I'll go 29, I'm hearing.
You can only take a date because the bench is not available, second of division bench is there.
All right, ma'am.
We can do a hearing in 10 minutes.
Well, as per convenience of the court, any date.
You ask